Hello everyone, I'm Jed Rubenfeld, and this is Straight Down the Middle with a Supreme Court end of term wrap-up. That's right, the 2025 season is over, and I'm here in this episode to give you an overview of the whole thing, so let's jump right in. Well, the court closed out its term with a string of much heralded victories for the right. The court ruled unlawful nationwide injunctions. For example, the court upheld a ban on trans surgeries and other procedures for minors, and in a final burst of 6-3 opinions, the court's conservative majority showed itself to be dominant and united. Well, all this, as you can imagine, has provoked some major hair-tearing on the left. The court is lawless, critics say. The court is unleashing chaos. The court has surrendered to the Trump administration, or in the words of Justice Jackson's dissent in the nationwide injunctions case, the court's rulings are an existential threat to the rule of law. Well, not so fast. In reality, the 2025 term, it wasn't really a barn burner. There was not a single case of the magnitude of Dobbs. You remember Dobbs? That's the case where the Supreme Court overturned Roe versus Wade and brought an end to the constitutional right of abortion. There wasn't a single case of that magnitude. There wasn't a single case of the magnitude of SFFA. That's the case where the court ruled unlawful and unconstitutional affirmative action at universities. There were no cases of that magnitude in this term. In fact, the entire term was more molehill than it was mountain. But the term did establish two things. First, it established that the right is winning the culture wars at the Supreme Court level. That's a big deal. That means the court has dealt some serious body blows to the left, and that's got to hurt. On the other hand, the second thing this term established is that we've got a court that is not kowtowing or surrendering to the Trump administration. And I don't care what your politics are, that has got to be seen as more important than the first development. In other words, even if you're on the left and you're getting hit with some body blows, you should realize that the fact that you got a court that is not kowtowing to the administration, that's more important. Now, let me give you an example. Take the nationwide injunctions case. Now, if you want to know more about the nationwide injunctions case, I did a whole episode on it. You can tune into that and learn a lot more. But as I said in that episode, this case wasn't really the hyper-partisan decision that many of its critics are making it out to be. On the contrary, judges and lawyers on both sides of the aisle had been objecting for years to the idea that a single district judge in, say, Hawaii could make law or make policy for the whole country. Everybody thought that was a little bit of a crazy idea. And in fact, don't forget, in the nationwide injunctions case, the CASA case, the Supreme Court left open some serious procedural loopholes through which lawyers and plaintiffs can still seek and obtain the equivalent of nationwide injunctions through other mechanisms, as, for example, by filing a class action. Now, why am I bringing this up? I'm bringing it up in part to say that the obituaries, the death of the rule of law that have been pronounced upon as a result of that case, much exaggerated. Yeah, they are exaggerated, but that's not actually why I'm bringing this case up to you. I'm bringing it up to you to emphasize the fact that the critics of the case rarely or never focus on the fact that the administration went to the Supreme Court in the first place and asked the court to do something about nationwide injunctions. Why is that so important? Well, why did the administration go to the court and ask it to do something about the nationwide injunctions problem? It did it because it is complying with judicial orders, including lower court orders. That's right. Now, you know, I know that hit with some judicial losses, the Trump administration will sometimes seek a workaround, another legal path to achieve the same result, but that is not the same as defying a court order. Don't forget, most presidents have done that in one way or another. Biden did it with his student loan forgiveness program. As you may recall, the Biden administration adopted a student loan forgiveness program, wiping out tons of student debt. Supreme Court struck it down and said, no, that's illegal. And the Biden administration instantly adopted another plan to do the exact same thing. In fact, Biden boasted about it. He said, the Supreme Court tried to block me from forgiving student debt, but it can't stop me. Now, that's okay. If you can find a legal workaround, go for it. That's not defiance. Now, I know there are some folks and a couple of judges who have said that the Trump administration, they're defying judicial orders. Judge Boasberg down Columbia District Court, he thinks that. But look, truth is, in every case, the Trump administration is in virtually complete compliance, or arguably 100% complete compliance with judicial orders, and that is why it keeps running to the appellate courts and the Supreme Court to have the district court orders put on hold or overturned. That's why the administration went to the Supreme Court and said, you got to do something about the nationwide injunction problem, because the administration is complying with judicial orders. Now, I can't stress to you how important that fact is. Presidential obedience to the judiciary, that's a thin red line that separates a constitutional rule of law republic from an autocracy. If the president does not obey judicial orders, well, then he can do whatever he wants. And there's a word for that. That's autocracy. Now, the amazing thing about that in our system is presidential compliance with the judiciary, it's essentially voluntary. No other branch in our government has the power to force the president to comply with judicial orders. The courts sure as heck can't do it. Even Congress can't do it. So it's up to the president, and you got to count on and believe in the president's compliance with judiciary, or else you're not going to be living in a rule of law republic anymore. And I remember when Trump was first elected in 2016, tons of lawyers and people on the left were saying he's not going to obey judicial orders, he's going to defy the courts. They were saying it so much I got a little worried myself, but guess what? In Trump 1.0, the administration complied with judicial orders up and down the line, right from the beginning, first week of his term. And in Trump 2.0, the administration is doing the same thing. That is hugely important. And all the folks out there claiming to be terrified of Trump's alleged dictatorial propensities, they ought to be bearing that in mind. And it's not true, by the way, that the reason why the administration is complying with judicial orders is because the Supreme Court keeps rolling over for it and kowtowing and surrendering to it. You know, I got to tell you, on this point, the most important case of the whole term was decided back in April. In April, you may remember, the Trump administration invoked this statute called the Alien Enemies Act. Because under that statute says that the president, under that statute, when it's properly invoked, he can deport certain foreigners, citizens of enemy countries, no matter how many there are, under processes and of the president's choosing to places of the president's choosing. Now, I got to guess that administration lawyers, they thought that by invoking the Alien Enemies Act, they had found a way to insulate the president's deportation policies from judicial review, because the statute says the president gets to choose the processes of deportation. So they thought, hey, we found a way around judicial review, no judicial review whatsoever. It's going to be great. They thought, but the Supreme Court threw a wrench in those plans. In a case called JGG, the court said, in a midnight order, it issued a midnight order and said, no, no, no. Every single deportee has a right to notice and a hearing before removal. And the court was right to do that, and that's a very big deal. Why is that? Well, the court was saying these deportees are entitled to due process. Due process. Without due process, without that right to a notice and hearing, well, folks could be disappeared in this country. Black cars could pull up to you in the street. Agents could jump out, throw a hood over your head, throw you into the car, and you find yourself in a black site, incommunicado, no right to a lawyer, family doesn't even know where you are. What stops that from happening? It's called due process, the right to a hearing. So you can go to a court and say, whoa, they got the wrong guy. Well, I'm an American citizen. I haven't done anything wrong. Without that right to a hearing, we would be the kind of society where folks could be disappeared, and America is not and cannot be that kind of society, and we are not, because of due process, which, along with presidential compliance with the judiciary, is the other foundational bulwark for the rule of law. And in JGG, the court said no to the administration and stood firm for due process and for the rule of law. Now, there's no question that the court has been favorable to many Trump initiatives. The Supreme Court, in its emergency docket in 2025, that's the docket where the court takes cases on a rushed basis, rather than the usual years it can take for the cases to filter through the system, get up to the Supreme Court, get decided. In the emergency docket, the court has been especially favorable to Trump administration initiatives. For example, the court has allowed the administration to deport aliens to third countries. The court has allowed it, and when I say allowed, I just mean like it has put on hold lower court orders. These are typically not cases that have reached the merits, but the court's allowed the administration to deport aliens to third countries. The court has allowed the administration to fire probationary federal employees. The court has allowed the administration to have DOJ given access to agency information and Social Security or taxpayer information. The court has allowed the administration to fire agency heads that were protected under previously existing law. Now, your view about any of these cases is going to depend on, whether you're on the left or right, what you think of the law in these cases. These are provisional cases, but, in my opinion, none of these cases was all that surprising. And in every one of the cases, the court's decision was legally defensible, put it that way, defensible. There was nothing crazy that went on there, but there were a lot of decisions that favored what the administration was doing. But you got to remember, when you look at those cases, you got to remember the judicial context in which they are occurring. This is a context in which the administration is getting slapped down a lot on a lot of its initiatives. For example, the Trump administration's executive orders targeting and attacking named law firms, struck down over and over in the courts. The Trump administration, some of its very aggressive attacks on Harvard University have been struck down in the Supreme Court. Just this morning or yesterday, a court halted the administration's plan to revoke the temporary protected status of hundreds of thousands of aliens who were granted temporary protected status by the Biden administration. The Trump administration losing a lot of these cases. Now, a lot of these cases are lower court cases, but the Supreme Court has not been overturning all of them. And in fact, the Supreme Court has been helping the lower courts do some of this in important ways. Don't forget, in the nationwide injunctions case, the court upheld the 3 district courts' findings that the Trump birthright citizenship order was unconstitutional and could not be applied to the plaintiffs in those cases. Now, don't get me wrong, the court did not reach the merits. The court itself did not find that the birthright citizenship order was unconstitutional. The majority did not reach the merits. But what it did do was it said to the lower courts, you all can keep, you can review that birthright citizenship order, and you can find it unconstitutional. And if you do so find it, you can hold that the plaintiffs before you are citizens of the United States, or their kids are going to be citizens of the United States. And the administration cannot take that away from them. So to be clear, what the court did in that case was that you lower courts, you can't issue a nationwide injunction, but yes, you can find that the birthright citizenship executive order is unconstitutional, and you can apply it to the plaintiffs before you. And don't forget, the court did something similar in the Alien Enemies Act case. The court said to the court did not reach the merits, but it said to the lower courts, you go ahead and decide whether the Trump administration's invocation of the Alien Enemies Act is constitutional or not. So the court is playing its part and saying, lower courts get to decide that. Eventually it's going to come to us, but lower courts can decide and make decisions. They can't do nationwide injunctions, but they can enforce and apply their decisions to the parties before them. On the other hand, when it comes to the culture wars, well, the court has been very firmly on the right and has been dealing the left a series, as I said before, of body blows. In addition to upholding that state ban on trans procedures for minors, the court in another case allowed the Trump administration to continue enforcing its so-called trans ban in the military. In another very important case cited at the end of the term, the court held that parents of elementary school kids in the public schools have a right to opt their kids out of LGBT content. Now, I did an episode on that case too, the Mahmoud case. You can watch that to learn more about it, but that's very important. Court held that parents have a right to opt their kids out of pro-LGBT content in the for little kids in the public schools. That's a big win for the right on the culture wars front. In addition, the court continued its takedown of laws and measures given favorable treatment to minorities. In an important case, the court held that individuals from majority groups, for example, whites, have the same employment discrimination rights as minorities do, and you can't impose on them special, on the majority groups, special evidentiary burdens that minorities do not have to satisfy. In some other cases, the court dealt some blows, gave some losses to the environmentalists. Court curbed the authority of the EPA. The court narrowed the scope of environmental impact statements for major infrastructure projects. These are important holdings. Case after case, you see the court favoring the right, the conservative side, in various culture war battles. But even here, the court was not monolithic or knee-jerk. In an important case over the dissent of Justice Alito and Justice Thomas, the court held that ghost guns, so-called ghost guns that are very hard to trace, can be regulated. In another case, again, over the dissent of those same two justices, the court granted a new trial to a death row inmate. So even here on the sort of culture war front, the court has not been monolithic. In short, in my opinion, this is the Supreme Court 2025 wrap-up. In short, in my opinion, it's not a dogmatic or a pro-Trump court. It would not be fair to use either of those terms with respect to the court in this term. This is a court that has reduced judicial authority vis-a-vis the executive. That's true. Nationwide injunction case, reducing judicial power, giving more power to the executive. But it's also a court that has reduced executive power vis-a-vis the judiciary. That's like the Alien Enemies Act case, reducing executive power in favor of the judiciary. And this is a court that does that all the time. And it's cases holding that executive officers do not get deference, as much deference as they used to in the federal courts. Yeah, I mean, there was a bunch of 6-3 decisions. All the conservatives line up on one side, all the liberals on another. There were 6 of those decisions. But actually, that's a smaller number of split ideological decisions than in 3 of the last 5 Supreme Court terms. So this term was not as ideologically split a term as others have been in recent years. It's definitely a conservative court, but which appellate court is the court that the Supreme Court took most appeals from? It's the famously conservative Fifth Circuit. The court took 12, or by some counts 13, appeals from the Fifth Circuit, the conservative Fifth Circuit, and how many of those cases did the court reverse? 10. So, look, yes, the court has favored the administration in a number of cases, but it is also a court that has stood up to the administration and stood firm when it comes to foundational constitutional issues like due process. And I'll make a prediction right now, if and when Trump's birthright citizenship order, which denies birthright citizenship to the children of illegal aliens and some legal aliens, if and when that finally comes out to the Supreme Court, I'll make the prediction right now, a majority will strike it down. Bottom line, for now, I don't care what your politics are. Everybody, regardless of your politics, should take satisfaction in the fact that the American legal system of checks and balances is still working. You may love a lot of the outcomes coming from the Supreme Court. You may hate some of the outcomes coming from the Supreme Court. But look, everybody should remember this. The rule of law is alive and well in America. That's all from me for now. I'll see you next time.